It is a pleasure to welcome, I guess, to this version of my program for the first time, but a frequent guest on some of my past shows, Scott Horton, writer for Harper's Magazine, among other attributes. Welcome to the program, Scott.
Hey, great to be with you.
So, Scott, let's go over. I mean, I think I think my audience is fairly aware of the basic outlines of what has happened at this point. We have now Julian Assange has been granted. My understanding is he's been granted diplomatic immunity as opposed to, asylum, as opposed to political asylum. Can you tell me the difference between those two?
Well, there isn't a big distinction in them. I mean, they have to do with the terms of his being housed, but the considerations are basically the same. So, asylum is granted to an individual who applies for it, who fears persecution, or in the more extreme cases, has fear of imminent physical harm from another government. So, it's actually granted against another government, and in this case, it's exceptional because the grant is occurred for the property of an embassy, because he went to the Ecuadorian embassy in London rather than going to Ecuador and made the application for Ecuador to give him asylum, which they decided to grant. Now, this is not unheard of. In fact, you may recall we had for a period of about a decade, we had a group of Russian Baptists who were granted asylum by the United States who lived in the American embassy in Moscow. We also had Cardinal Minczynski, one of the most prominent political and religious figures in Hungarian history, who also lived for more than a decade in the American embassy in Budapest. So this is, I'd say, a very well-established practice, but not that common. It happens every few years.
Give me a sense, characterize for me the Ecuadorian decision here. I mean, I would imagine that asylum is granted in different situations with a greater and lesser degree of, I guess, due diligence, or with the qualitative decision making here. I mean, Ecuador isn't necessarily considered one of the greatest places in the world for freedom of the press, but they seem to have done a very significant amount of due diligence here, speaking both to the Swedes and to the Brits and to the U.S. Is that your sense?
That's right. I mean, there have been a number of editorials that have appeared in the United States that have said, oh, this is all just this crazy dictator in Ecuador trying to slap the American government and the British government across the face. It's just a publicity stunt. That's not really right. I mean, actually, their Minister for Foreign Affairs appeared and read the decision that they granted, which was really extremely detailed, and it was based on a long recitation of facts and investigation that they conducted. And to me, what struck me most about it is that they quite rigorously followed the technical legal criteria that are applied for deciding grants of asylum. So they went through the question of whether his petition was grounded in fact, whether there were threats that had been made against them. And they noted that, we put questions to the Swedish government, to the British government, to the American government, and didn't get much response from them. But then we also independently investigated, and we found, for instance, that a DoD spokesman did say that Julian Assange had blood on his hands. That Department of State spokesman said that Assange had put the life of American personnel in jeopardy, that there were a number of American congressmen who said that he was guilty of treason, that there were 4 political figures who called for the death penalty against him, that a former Speaker of the House of Representatives stated that he should be assassinated. In fact, I've been involved in many political asylum cases in the United States involving prominent foreign political figures, and this is exactly the character and nature of evidence that usually is collected and considered by an American immigration court in making that determination. So I would say they did it in a technically precise and correct way.
Now, let me ask you this. One of the questions that people have discussed is, why would how are the extradition treaties, or how is the situation different, so that that Britain would not extradite Assange to? I mean, let's assume for the moment that there is a sealed indictment waiting for Assange, or that one is imminent from the grand jury. Why would not the Brits simply extradite him as opposed to the Swedes? I mean, in other words, why would he have to go to Sweden to put himself in jeopardy as opposed to where he was in Britain?
Well, I mean, the bottom line answer to that is that there is both a practice and a technical legal predicate for rendition between Sweden and the United States, and there is not between the UK and the United States. That may sound strange because we always talk about there being a special relationship with the UK, but in fact the UK insists on a much more formal legal process. And Sweden has cooperated with the United States repeatedly in rendition. Now, rendition means that there's no formal extradition procedure. They just put someone on a plane and ship them off to the U.S. immediately. And there may not even be an opportunity to contest it. And in this case, both the Ecuadorian government and Assange's attorneys have asked both the U.S. and Sweden to deny this, and neither Sweden nor the U.S. would deny it. So, in fact, I'd say there are a lot of circumstances. I'd say there's no clear proof of there being such a wink and nod agreement between Sweden and the United States, but there's a lot of circumstantial evidence that would suggest that the fear that Assange is articulating is certainly not crazy. It's quite realistic.
Interesting. And do you think that, I mean, from the UK's perspective, how I mean, I guess how has their actions been? I mean, both. I want you to characterize one, the threat to storm the Ecuadorian embassy, which I think by all accounts is fairly unprecedented, but also characterize what you see as the relationship between the Swedish authorities and UK authorities in terms of their request for the custody of Assange. Do you think that the UK, do you think the UK is conscious of what will happen to Assange, or if he goes to Sweden, or have they, and is that indicative of their threat to storm the Ecuadorian embassy?
Well, so, I mean, let's deal with that threat first of all. I mean, I was when you first called me about this, I was giving a presentation at the Practicing Law Institute where I appeared with a very prominent, very conservative American international law scholar, Malvina Halberstam, who told me she was absolutely appalled at what she heard the UK threatened to do to storm this embassy. I mean, you know, this is not a question of politics or attitude. I mean, the law in this area is absolutely clear-cut. You may not do that. And this is the sort of threat that rogue nations make. I mean, like, I would expect this to come from the Iranians or the Syrians or something, but not to come from the UK. So that was really, I think, had a lot of people completely aghast that they made this threat. And then secondly, I'd say, yeah, there's something about this that just doesn't quite stand up. I mean, Assange does not face any criminal charges in Sweden. There's only an investigation going on. There's an investigation, and the investigation itself is highly controversial, with some very, very prominent Swedish legal figures saying that this is just hooey. There's no basis for any criminal action here, including the former Arnholm, the former prosecutor general of Stockholm, who said that this is nonsense. It's some sort of intrigue. And we know that when the process was first opened based on these complaints, the senior prosecutor in that district shut it down, and then it was strangely, again, reopened. So there's something really odd there. Now, you know, the major complaint that Assange brought in this case in the British courts was that Britain had a duty to ensure that this was not just some sort of collusive arrangement between the U.S. and the Swedes where he was going to be sent to the U.S. to face espionage charges or heaven only knows what. And the the British courts, going all the way to the top, basically said, well, you really don't have enough evidence of that to push it. And Britain really is committed through its treaty undertakings with Sweden to go ahead and turn someone over for inquiries, even when there is no pending criminal charge. So I say, what's going on is highly unusual, but not impossible legally, but it definitely points to there being something under the surface here.
Right, and Britain's. It's one thing to say that they are obligated to send someone back to Sweden for questioning. It's another to say that they will actually take that obligation to the point of saying we will storm an embassy that has provided asylum to him. Right?
That's exactly right. And in fact, you look at a lot of the stories that have been presented in the British press about how this is an affront to British sovereignty and British dignity, and the Ecuadorians are attacking Britain. It was described by the Sun as the Second Falkland Islands War. This is all total nonsense. This really has nothing to do with the UK. The UK is an intermediary acting on the Swedish request. So, and in fact, the party of interest in the background really is the United States. The important thing to consider here is that if the U.S. is looking at this, it's a national security violation in the U.S., a whistleblowing offense or something of that sort, and that is the sort of claim or charge for which a country frequently cannot get the cooperation of a foreign country. Because this is a sort of crime which we would say is essentially political in its nature. So, any country can charge such offenses and try them in their courts, but countries usually don't cooperate with one another in the enforcement of political crime.
And we should say, just to that point, the Sydney Morning Herald reported at the end of last week, I should say, that through Freedom of Information requests, they reported that at the very least, Australian authorities are operating under the assumption or the belief or is anticipating the receipt of an extradition request for Assange from the U.S. So that's just more evidence that there is there is at least some type of charges waiting for Assange in the U.S. And tell me, do you know anything about how Sweden charges someone with a crime? I've read contradicting reports that they can't charge Assange in absentia. Is that true to the best of your knowledge, or is that not true?
It is true that they can't try someone in absentia, but they can charge someone in absentia. So there's no reason why they wouldn't be able to bring charges right now. But of course, it's also a procedural norm that prosecutors usually don't want to bring charges until they've had an opportunity to interview principal witnesses, and they're considering Assange to be one. And what is the crime or offense here? It has to do with Assange having sexual relations with two women who both have told prosecutors that they consented to have sexual relations with him, but then withdrew the consent in the course of the sexual relations, and he continued and completed the act. So let's just say this is the sort of thing which is not charged as a sexual offense in any country in the world I'm aware of. I'm told that, it is a violation of the law in Sweden, apparently, but there's no real record of the Swedes prosecuting anyone for this. This is one of the reasons why a lot of people in Sweden just say this just doesn't pass the smell test.
Yeah, I think from my perspective, the issue is simply I'll leave it to the Swedes to determine what their law is. But if he can be charged while he's outside of the country, and to my understanding, he has been questioned already once. But we're going to be talking to Michael Ratner in just a few moments, and so we can get that clarified. Scott Horton, I appreciate your weighing in on this. Is there anything else that you think that we're not that needs to be touched on?
Well, I think one thing I would just focus on is one of these early WikiLeaks documents was a leaked U.S. Department of Defense dossier that said that provided a strategy for battling WikiLeaks, and it basically talked about using dirty tricks and very aggressive techniques to go after the leadership of the WikiLeaks organization and their financial resources. So we know that the U.S. government was planning to use, let's say, dark means to try and shut WikiLeaks down. I think if we look at what's happened to Julian Assange and the WikiLeaks organization subsequently, I think you could put together a case that that game plan may very well have been implemented.
Scott Horton from Harper's Magazine, thank you so much for joining us.